Good evening and welcome to the thorough newspaper analysis by LawSikho for the 24th of June 2023. Now, today we have one editorial article which has been taken from Hindu and is titled The UAPA Fiasco in Telangana. For the second and the third segment today, we will have the news update and the legal news respectively. So, with regards to today's editorial article, that is the UAPA Fiasco in Telangana, it involves Yedla Kishore, who is an activist. He's writing a letter to the Rangareddy district judge seeking information on how many cases were filed against him. Now, normally, when accused under UAPA go forward to approach the authority, their letters or their pleas are generally brushed under the carpet. However, since this was a district judge who was involved, he immediately went forward and ensured that the Telangana government would come forward and reply to his queries. Now, the reply to this query has brought out a huge number of cases. There's a 52-page FIR in question, and there are 152 suspects named in it who have been accused of various charges, but none of them have either been issued with a summons or their details have not been verified. No sort of action has been taken. It's just that a case is there under their name pending. Now, the reply to the query brought out a huge number of cases pending against prominent individuals, although there was a dearth of evidence. Now, why prominent individuals? There's apparently a couple of lawyers who have been named in these FIRs. There's also one justice who has been named based on not that they actually went forward and incited something, but based on the fact that their names were found to be written in a Maoist pamphlet. Now, the gaping holes regarding the entire way the Telangana police has been dealing with the complaints. The 52-page FIR has a plethora of missing actions. Firstly, it lists Justice Suresh as one of the accused, and this is a 2022 incident. However, Justice Suresh died in October 2020, and yet there is an FIR pending against this individual. The police did not make any efforts whatsoever to verify the information that they were collecting. Some of the lawyers who have been booked under the UAPA, no actions were taken by the police to verify whether these lawyers were actually lawyers or not, or if the addresses that have been recorded in the FIR were actual addresses. And neither was there a satisfactory answer on why the police did not issue summons against the 152 accused. Now, if it is true, if these people were actually guilty of the provisions that have been stated under UAPA, which in itself is a very grave act, and committing an offense under UAPA is actually a very grave offense. So, if there's a 52-page FIR in question that has 152 accused, then why not issue a summons against them? Now, the charges under Section 3 of UAPA have been brought forward. Now, when we talk of Section 3 of UAPA, this is often used by police, rather malevolently, to keep people in check, that is, use their powers in a wrong manner. And when we talk of the way police has been acting, or rather the police has been misusing the power of UAPA, we must not forget that the UAPA Act in itself has garnered a lot of criticism. Major human rights organizations have called it a very cruel and a stringent act. In addition to this, Section 43, subsection D, subclause 5 of the Act requires the judge to have sufficient proof in order to deny bail. The issue also arises when the judiciary seeks to prosecute before granting bail. Now, we have seen this in a couple of cases where the Supreme Court has come forward and reiterated countless number of times that it was the right of the accused to get bail until and unless the situations were in a certain manner that the accused could not be given bail. However, if there is a constant tendency of the judiciary or the lower courts to go forward and prosecute the accused before granting them bail, it does create a lot of financial and emotional strain on the person, let alone setting aside and completely derailing the way our entire judiciary works. Now, confession statements that have been forcefully obtained by the police are also used indiscriminately to book cases. And once the cases are booked, a spree of similar cases are now slapped on the accused, which creates a further emotional and financial toil on the accused because these cases are known to go on for a very long time. Now it's up to the Telangana government to see what they will be doing with the charges that have been alleged against the Telangana police, and overall how the entire UAPA Act keeps on working in the country, and if any amendments are introduced into the Act to make light of the provisions which have been very infamous for being used malevolently. Now, with that, we move on to the new segments for the day. Firstly, we have India US to launch joint mission to space in 2024. NASA and ISRO have agreed to launch a joint mission to International Space Station in 2024. Prime Minister Narendra Modi also signed the Artemis Accords, a non-binding multilateral arrangement between the US government and other world governments participating in the Artemis program, which is a US-led effort to return humans to the moon by 2025. Secondly, we have Skyroot successfully tests Raman-I engine. Hyderabad-based Skyroot Aerospace, the private India space company, has accomplished the flight qualification trial of Raman-I engine intended for roll altitude control in their forthcoming Vikram-1 rocket. The engine underwent a test firing at the Indian Space Research Organization's Liquid Propulsion System Center, marking Skyroot as the inaugural private company to employ this facility. This is the first ever test done at ISRO's LPSC by a private company. The series of tests resulted in perfect completion with 280 engine pulses with a total burn time of 104 seconds. Next up, we have a very significant show by the Indian cohort in the Special Olympics, where India crosses the 50 medal mark. At the end of the day's action, the Special Olympics Bharat team or the Special Olympics Bharat cohort had 55 medals, 15 gold, 27 silver, and 13 bronze spread across five different sports: athletics, cycling, powerlifting, roller skating, and swimming. The highlights of Wednesday's medal rush came from the swimming and cycling course, where India registered five wins in the pool: three golds, one silver, and one bronze, and six on the cycling course: three gold, two silver, and one bronze. Next up, we have India United States Defense Acceleration Ecosystem, or the INDUS X, launched. The India United States Defense Acceleration System, or the INDUS X, was officially launched on 21st June at an event held in Washington, D.C. The initiative aims to foster collaboration and innovation between the Indian and US defense startups, promoting technological advancements in the sector. Co-organized by Innovations for Defense Excellence, or the IDEX, under the Ministry of Defense and US Department of Defense, the two-day Indus X event brought together government representatives, defense industry leaders, think tanks, investors, and startups from both countries. We also have Sakshi Kochar, who becomes the youngest Indian to get commercial pilot license. Sakshi Kochar, who was born on the 30th of May 2005 in the town of Parwanu, Himachal Pradesh, has broken the record to become the youngest commercial pilot in India. At the age of 18, she achieved this milestone, surpassing the previous record held by Maitri Patel, another female pilot from India who obtained her commercial piloting license at the age of 19. In the international news segment of the day, we have the sad news that OceanGate's Titan submersible imploded. OceanGate's Titan submersible, a 6.7-meter vessel which was operated by the US-based OceanGate Expeditions, lost contact with its support ship about an hour and 45 minutes into what should have been a 2-hour descent. After an undersea rowboat discovered debris from the submersible about 487 meters from the Titanic's bow at the wreck's depth of 3.8 kilometers, the US Coast Guard concluded the vessel suffered a catastrophic implosion, killing the five men and ending any hopes of a rescue. The only thing that the researchers have said in this regard is that the death was probably painless because at that depth, the death was so sudden and so fast that it was impossible for a human being to feel anything. Next up, we have UK net debt passes 100% of GDP for the first time since 1961. The Office of National State Statistics said the net debt reached 2.6 trillion at the end of May, estimated at 100.1% of gross domestic product. It is the first time the debt to GDP ratio has risen above 100% since March 1961, except for during the pandemic, but this was later revised lower due to stronger GDP figures. It came as government borrowing soared year on year to 20 billion euros in May, pushed higher by the cost of energy support schemes and inflation linked benefit payments and interest payments on debt. In the next news for the international news segment today, we have UN adds Russia to its list of shame over Ukraine war. In an annual report on the treatment of children in conflict zones, UN Secretary General Antonio Guterres said that he was appalled by the high number of grave violations against children in Ukraine committed in 2022. According to the document, 477 children were killed in Ukraine last year, including 136 deaths attributed to Russian forces and affiliated groups and 80 to Ukrainian armed forces. A further of 909 children were maimed, 518 of them by Russian forces and proxy groups, and 175 by Ukrainian forces, the report said. We also have Egypt to offer exclusive industrial cluster to India in Suez Canal EZ. Egypt is ready to provide India with an exclusive cluster in the industrial and logistics hub, which could act as a portal for New Delhi to reach other markets more efficiently, the chairman of the Suez Canal Economic Zone said. Egypt offers unique opportunities to Indian investors to reach out to markets such as Africa, Europe, West Asia, and Latin America. We also have the UN Public Service Day, which is commemorated on the 23rd of June. Now, with the aim to appreciate the value of public institutions and public servants, this day is celebrated on the 23rd of June. UN Public Service Day celebrates the value and virtue of public service to the community, highlights the contribution of public service in the development process, recognizes the work of public servants, and encourages young people to pursue careers in the public sector. The origin of the UN Public Service Day goes back to December 20, 2002, when the General Assembly selected June 23 as the Public Service Day after adopting a resolution 57/277. Now, for the International Olympic Day. The International Olympic Day is held again on the 23rd of June every year. The day is celebrated to encourage more people to participate in the Olympic Games and spread awareness about the event and promote the Olympic movement. Based on the three pillars move, learn, and discover, the National Olympic Committees are deploying sports, cultural, and educational activities to encourage participation regardless of age, gender, social background, or sporting ability. For the legal updates of the day, we have decision to allot additional shares cannot be set aside merely because promoters have also benefited. The Supreme Court, in the case of Hasmukhlal Madhavlal Patel and another versus Ambika Food Products Private Limited and others, has upheld a largely disproportionate allotment of right share in favor of one group of shareholders of a private limited company, substantially increasing its shareholding percentage in the company over the group of shareholders. The bench found that the increase in the appellant, H.M. Patel Group's shareholding from 30.80 to 63.58% of the paid up share capital of the private company was the result of other shareholder groups' refusal to apply for the additional shares despite being given the opportunity. Thus, the allotment of fresh shares could not be characterized as oppressive. Secondly, we have ordered under Section 16 of the Arbitration and Conciliation Act can be challenged under Article 227 only in exceptional circumstances. And this is something that the Calcutta High Court had to reiterate again. Now, the Calcutta High Court, in the case of MD Creations and others versus Ashok Kumar Gupta, has reiterated that the remedy under Article 227 of the Constitution of India against the order of the arbitral tribunal rejecting the challenge to its jurisdiction under Section 16 of the Arbitration and Conciliation Act 1996 can be invoked only on ground of the arbitrator's patent lack in hearing jurisdiction, in inherent jurisdiction, or exceptional circumstances or bad faith on part of the other party. So this was all for today. For free study materials and TNA PDF slides, please join our Telegram channel, the link of which you can find in the description, or you can scan the barcode that is given on your screen. Also, don't forget us Don't forget to subscribe us on YouTube and stay up to date with the thorough newspaper analysis and any other videos on current affairs as they come up from time to time. Thorough newspaper analysis comes out every day. Thank you.